really publishing decisions of the Anti-Monopoly Committee. It's no less important than recommendations about the sanctions and penalties. First of all, about transparency and predictability, and as well the highest number of complaints about the previous authorities in Anti-Monopoly Committee about non-transparency and no publications of Anti-Monopoly Committee decisions. So the law firms and public, they are not aware about the approaches. They have no possibility to get it, what have been adopted and whatever. Sergey, can you do this for me? It's probably about slides. And the issue on publishing the decisions of Anti-Monopoly Committee, that's our obligation in accordance with EU-Ukraine Association Agreement and the law that requires committee to publish all the decisions have not been approved yet in the parliament, and about 1.5 months the decisions have been adopted without expecting the law adopted in the parliament. Publications have to be started, and publications have to perform the major functions that were specified above, and as of today, more than 1 month of practical application of this publishing of the AMCU decisions, we can see what problems arise. The most sensitive issue when we are talking about publications, the permits for concentrations. When we are getting appeals with respect to identifying all the information as not for disclosure information, and applicants provide absolutely no information why this information is confidential or not for disclosure. That may damage the interests of commercial entity. And you can get these publications on the website. The company A is planning to buy shares of company B. Nothing about approaches of the committee, all the way to the situation that not for disclosure are even types of operations, types of activities, and types of concentration that's not for disclosure or information. And then about applying sanctions for infringement, situation is even worse because the applicants are actually requiring to make it not public. Even adopting decision by the committee that this company A is liable. No arguments about it. And about publication may damage the interests of the companies. And as a result, publishing decisions with respect to application of sanctions never happens.
Legal grounds on publication decisions. I would like, just in view of the recent amendments just to the law on the access to the public information, the Article 6 provides just the restriction in the access to information while complying with 3 requirements, which will be taken into account while making subsequent decision on a publication. An important provision is in the this article of the law, which says that the restriction to access is just tended to the information, but not to the document itself. As the committee presently sees such an issue that we have we have agreed to comply with this function, but it doesn't perform the main function of such a publication, because it's of conventional character. We don't have the opportunity as of today to step beyond these borders, but the law on the access to the public information and the legislation on information just defines a mechanism according to which entities should provide information. Why conventional information is not for disclosure, but in what particular damage will be caused to the interests. Recognizing such problems that we have, it's in the plans of the committee to resolve issues how to disclose information in this particular case. Therefore, if there are no arguments why particularly this specific information is to be classified, the committee would be obliged to publish it in view of provisions of Article 6 of the law. In what way? From the point of view of the legislation, how these approaches are to be defined in future, probably as a part of compliance programs of the Anti-Monopoly Committee, or probably a template will be created with regards to information that cannot be specified as a classified information. Basically, this issue is in discussion the Anti-Monopoly Committee, and probably there will be some public comments, including how to categorize information into three types. The information access to which cannot be restricted. Such information is specified during consultation, and information which is not subject to disclosure. Because certainly we understand a huge massive of the commercial information, including information that is used for providing permits for concentration, because it can cause great damage to the stakeholders in the discussions. And as of today, we would like to apply representatives of the law firm communities, that those applications which already have been submitted to the committee, we would like to get from you additional arguments as for classifying information and specifying the information as information with restricted access, because we think that in near future this issue will be raised by the committee and will be decided in each particular case. In principle, that's all.